Assalamu alaikum warahmatullah, brothers. Nasir bhai, inshallah, we can start when you're ready.
अस्सलाम वालेकुम नबील भाई, जज़ाकल्लाह खैर। आई थिंक 2 या 3 मिनट और वेट कर लेते हैं, लोग चुके भी ज्वाइन कर रहे हैं, तो 2 या 3 मिनट बाद शुरू करते हैं।
Nasir bhai, should we start, inshallah? Sorry, my mic was off. Yeah.
Let's give another couple of minutes, Nabeel bhai, if that's okay.
Okay, inshallah.
We open the document that you send in parallel, or how would it?
Yes, please. Yeah. So you can either, if you've got printed one, you can just use that one. Otherwise, you can open it in parallel, inshallah. Yeah. So we sent one document for bringing along in a printed form for this workshop. I'm not sure if it has reached you or not. All right, that'd be great.
Let me see if I can put that into.
That'd be great. Yeah. And I'll put in the other meeting. So those brothers who have got the PDF editor, they can edit it online. Otherwise, you can just make notes and complete it later on.
Assalamu alaikum. Sorry, can someone share the document here?
And I've copied it for the participants of the meeting.
If you want.
So brothers, the topic is long, so maybe we should.
Yes, we can. I think it's 8:05, so Nabeel, off you go. Yeah, off you go. Yeah, Jazakallah.
Inshallah. So inshallah, we'll make a start. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. Innal hamdalillah nahmaduhu wa nasta'inuhu wa nastaghfiruh ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلله فلا هادي له وأشهد أن لا إله إلا الله وأشهد أن محمدا عبده ورسوله. So inshallah we'll make a start. So this workshop is about Islamic wills, and inshallah before we start I'll just present a little bit of an overview. So this journey started when I completed an ijaza with one of my teachers in Pakistan. And after I completed that course, that was in Ilmul Miras, and what is called the Science of Inheritance. And after I completed that course, my teacher asked me to go and train people in Australia on that thing. So I came and consulted with my colleagues and other brothers in iCAN over here, and they suggested that there would be very few people who would be calculating the shares themselves. So what would be more beneficial for them is the concept of wills and how to make them in Australia and so on. So that's what we did then. So the pictures that you see on your screen are the first workshop that we did. And after that, alhamdulillah, we have done several workshops in WA. So now Nasir Bhai requested that we should also extend it to New South Wales. So that's why we are holding this session, inshallah. And as I mentioned, my main specialty is in the science of inheritance, but I'm not a lawyer. So what I'm sharing with you is based on a lot of research that I have done after completing that ijaza course. And also the will document that we produced, that was we consulted about that with a number of other people, number of experts and so on. And then alhamdulillah, we finalized it in the form that it is in. And it has also gone through a process of evolution. Initially, it was a very long, different sort of a document, but then again, we revised it and made it more user-friendly. And also, alhamdulillah, it meets the legal requirements in that regard. So that's our overview. And on the screen, you can also see a recording of one of the previous sessions. So that is also available, inshallah. We will share the presentation and you can access that as well if you find any confusion or want to go through that. Moving on. So as I mentioned, how we have come to the point that we are standing on. So we have done extensive research on various aspects of the will as outlined in the law. And during this presentation, you would see references to various acts. So you would see references to the Wills Act in WA, as well as the New South Wales Succession Act 2016. So wherever applicable, we have put the references for that one. Also, before we came up with our will, we reviewed several other will documents. So various organizations offer the Islamic wills. So we have gone through their templates and critically studied them, Islamic as well as others, from Australia as well as from abroad. So approximately around 25 will documents we have studied, and then we have come with the one that you have access to, and you can see the link of that in your chat box. And also, alhamdulillah, we consulted with various experts and they were all happy with the documents that we have got. Another thing I would like to clarify before we move on, and that is that initially we used to do this course in 8 hours, and we used to cover everything in a lot of detail. But the last one that we did was in 2 hours. And we planned to do it in 2 hours, but it approximately took us 2.5 hours. So just a disclaimer that it might get a little bit over time, and I hope the brothers would be okay with that. It might go a little bit over time, but I'll try my best to cut out the details and keep it as simple and short as possible, inshallah. So when you attend this training or the workshop, I request you to know about or consider yourself in the shoes of these 3 roles. The first role is the testator. These 3 terms are extremely important. So testator, who's a testator? Testator is the one who's making the will. If you are making the will, you are the testator. Then executor is the one who would execute your will. You have mentioned certain things to be distributed in certain way in inheritance. Then executor is the one who you are authorizing to execute that will on your behalf and dispose the properties to the relevant beneficiaries. So these are 2 of the very important rules. Then you should also attend this training considering yourself as a trainer, because some of you might have joined with your spouses, but many of you, I think, might not have joined along with your spouses. So it's very important, just like text document, Will also has to be made by the husband as well as the wife. So you would be as a trainer as well. So after you complete this training, convey these details to your spouses so that they also understand the relevant requirements, because they have to make their own will as well. So these are the 3 important roles you should consider yourself in while you are attending this workshop. All right, now we will discuss what is a will, what is the purpose of the will, and what does it contain. So first of all, this will is a religious responsibility. So how it is like that, we'll discuss shortly. In the will document, you can communicate your burial preferences. Extremely important, because if you don't communicate these requirements, then the government would decide whatever they have to decide. There have been instances where Muslims have been cremated. So in order, especially important for the converts, because their family, their parents who are not yet Muslim, they would decide on their behalf what they have to do with the body. So if we don't communicate our burial wishes, then they would do whatever they consider as appropriate. So it's extremely important to use this function of the will. Then you can nominate the person who would administrate your estate. So the person who's making the will is testator, and what that person leaves behind is called estate. So that's what estate is. Whatever your properties, assets, etc., that you are leaving behind, that's your estate. And the person who you nominate to do that, to distribute your estate, would be called the executor. Now, this is very important. Now, these are some of the terms that normally we don't know, we don't hear about the words like that, but it's important to understand the definition from the will, from the perspective of will, because sometimes you would be making your own will. Other times you would be executing the will of others. So some of you might be the executors for each other. So that's why it's important that you understand these terms and what are your responsibilities in that regard. And then will is also important in order to distribute your estate Islamically. Estate, again, what we leave behind is called estate. If we don't leave that, then government has got their own formulas. So there are different formulas that have been mentioned in the succession law. So government will work according to that. But it's our Islamic responsibility to make sure that we distribute the estate Islamically, and we'll explain shortly why and how. Also, if we don't make a will, then there would be excessive legal fees that our heirs would have to pay and take the burden off. So that's why it's important to make the will. Also, through our will, we can benefit the charitable causes. We'll see how it happens, how to do that. We can also avoid excessive time in the distribution of estate if we make a will. If we don't make a will, then what would happen? They would look for the beneficiaries, and then someone would have to apply for what is called the grant of administratorship. Then it would take a significant amount of time, and then again, there would be time required to distribute that. So if you make a will, then you can save that time for your dependents, for your beneficiaries. We can also incorporate the details about organ donation in our will, but there are some other things that go along with that. So we'll inshallah cover that. You can nominate a guardian for your will, for your children in your will, and you can establish trust for the minors. What is a trust? We'll go through that very shortly. Okay, so now let's see why we are doing this session. There are 3 main objectives. Our first, primary, and most important reason why we are doing it is because it's the command of our beloved Master Sallallahu Alaihi Wasallam. So we are trying to fulfill his commands. And we have been told in this hadith that you can see on your screen from Sahih Al-Bukhari, it is duty of a Muslim who has anything to bequest to not let 2 nights pass without making a will about it. So if you have got anything about which you have to make a bequest, then it is very important that 2 nights should not pass that you should have a will about it. Now, if we look at us and analyze and assess our situation, many of us have got many things to bequest, and yet our wills are not ready. So this is a very painful point and a moment of realization that unfortunately how far we are from the Sunnah at the moment. So may Allah subhanahu wa ta'ala protect us. Ibn Umar radhiyallahu anhu used to say, Not even one night passed me ever since I heard this from the Prophet ﷺ without having my will with me. So that's the spirit that we should also have. One night should not pass unless we have got this will. After we have heard this hadith, now we should not even let one night pass before we have got a will available with us. So Alhamdulillah, you guys have got the format with you and you can fill that format. And the good thing, inshallah, is that you can fill it as we are doing the session. And as we discuss each element, you can complete the relevant section or afterwards. And inshallah, you can also send me email or maybe call me anytime if you need any help, because we only do it for the sake of Allah subhanahu wa ta'ala. We have no other objective. And that is why there are many organizations who charge $200 or plus or more for making the Islamic wills. But we only do it for the sake of Allah. We don't need anything in this world. So we have no problem in offering our services, consultation, anything, anytime, inshallah. Also, we can see this ayah from Surah Al-Baqarah. It is prescribed for you when death approaches any of you, if he leaves wealth, that he make a bequest to parents and next of kin, according to reasonable manners, in a reasonable amount. This is a duty upon al-muttaqun. Now here, I would like to emphasize a very important point. Many of the scholars of tafsir say that this ayah is abrogated. Abrogated means that Allah subhanahu wa ta'ala gave an initial ruling and then Allah subhanahu wa ta'ala replaced it with something else. So this ayah was before the specific shares of inheritance were prescribed. Now, the beautiful thing about the Quran is that it doesn't outdate. This was applicable before those rules came, but in Australia and in many other countries, it is still applicable and it is not abrogated. Because over here, we do not have those shares automatically in place. So we have to make a bequest about those shares. So that's the beauty of the Quran. It never outdates. So even though it's abrogated in, considered as abrogated in some parts of the world, in our part of the world, it is still applicable. Similarly, it is mentioned in the Quran, it is not for a believing man or a believing woman when Allah and his messenger have decided a matter that they should have any choice about that affair. So it is not up to us to decide what we have to give and to whom. Allah and his messenger has very clearly defined the shares of inheritance. And it is in our control. It is in our hand that we can write a will and distribute our assets Islamically. If we don't do that, the assets would get transferred according to whatever formulas are, and they are not aligned with what the Islamic shares are. Now, something is in hand. It is in our hand to fulfill the command of Allah subhanahu wa ta'ala, and yet we don't. We'll certainly be answerable for that. So that's why it's very important to make a will according to the Islamic principles. Second point is that we mentioned that it's also our responsibility from being an Australian, it is our responsibility. And why I say that is that because 50% of the Australians die without leaving a valid will. What happens as a result? Significant burden is put on the government legal machinery and also on a number of other institutions. So that is why government also wants that we should make a will. We should not die intestate. Intestate means that a person dies without leaving a valid will. So that's our responsibility as Australians as well. So I'm just quickly covering some of the things. So if any brothers on any of the meeting links feel that the things are going too fast, you can just let me know, and inshallah we'll slow down and we'll repeat things. If not, I'll think that everyone is comfortable and I'll continue going at the same pace. So the next important topic that we are going to cover is the testamentary capacity. Will is also called testament, the final testament or the last testament. So testamentary capacity is that a person has got the legal capacity to make a will. Yes, this is a question from a brother. Is this meeting recorded? The answer is yes, it's being broadcasted live. And also we have got recording available of a previous session. So inshallah, you can go through that. And the template is also shared in the comments box. In one of the meeting, in the other meeting, if it's all not already shared, then some brother can share, please, inshallah. All right, so we'll continue with the testamentary capacity. Now, it is one of the requirements for the validity of the will that you should make a will at a time when you are capable to make it. And what is that capability? You should have achieved the age of majority. You should be above 18 years of age. You should have sound mind. A person of sound who's not of sound mind cannot make a will. And that also includes people who are suffering from certain diseases. If they are in a capacity when they cannot make a will, they cannot interpret things properly, they cannot understand things properly, then that will would be invalid. That will would be considered as null and void. So it's important that you should make your will while you have got the capacity. And there have been instances where the will has been nullified by the court. So the court said that when the will was made, the person was not in the right testamentary capacity. So, and that normally happens when our heirs, when our beneficiaries, which are mostly our children, when they challenge the will in the court. And then they sometimes say that when my father or mother made the will, he was extremely sick, or he was not in the sound mind, or he's under the influence of drugs, alcohol, medicine, and other things. And that is why this will is null and void, because they want higher shares and so on. So sometimes this happens. So as you can see on your screen, there's a reference to a court case in which there was a dispute. As you can see, same family. So family members filing complaints and cases against their own family members. And then the will was considered as null and void because the father was mother was not in the testamentary capacity to make the will. And another thing to note is that the same requirements that we have in the law are also applicable Islamically. Islamically also, you should make a will when you have got the right capacity and the right mind. Summary of this point is that we should make the will as soon as possible if we are in the right capacity and if we are of the right age. Now, many brothers and sisters ask this question that in Australia, is there a particular format on which we should make the will? The answer is no. It does not have to be any particular format. There are certain requirements. If you meet those requirements, your will is valid. Even if it's written on a piece of paper, even if it is typed, if all those requirements are met, then the will is valid. So what are those requirements? We'll just read. The will itself should preferably be typed and computer printed, although handwritten wills are also acceptable under certain conditions. The will should meet the validity criteria for the relevant state. Failing to do so, the will would be considered by courts as null and void. So what are those conditions? We'll shortly see. That mainly revolves around witnesses and how they sign. In their presence, the document should be signed and so on. All these conditions will, inshallah, shortly cover. What is a valid will? So the valid will, according to the law, it is a will which is in writing. It cannot be verbal, it cannot be tape recorded, it cannot be video recorded. It has to be a typed will, written down will, either by hand or typed. It has to be signed by the testator or on his behalf, but in his presence. If, for example, if someone cannot move their hands and so on, but they have got the right mental capacity, they can make a will and it can be signed on their behalf in their presence. Also, the testator, the one who is making the will, makes or acknowledges the signature in the presence of at least two witnesses present at the same time. So you need at least two witnesses who should be present at the same time. So minimum, there has to be three people, yourself and two witnesses. And then they all have to sign in each other's presence to make sure that the will is properly witnessed. The witnesses attest and subscribe the will in the presence of the testator, but no publication or form of attestation is necessary. So once you have done that, it is properly witnessed, then you don't need to publish it in a newspaper or somewhere, or you don't need to get it attested and so on. So inshallah, what I'll do is that I'll take the questions in maybe certain breaks. So you guys can type the questions and inshallah, I'll read them after we reach certain milestones within the presentation, inshallah. Because the time is critical. So we used to do it in one day, but we'll try our best to finish it in 1.5 hours or 2 hours, inshallah. Considering the disclaimer that I mentioned in the beginning, that it might run a little bit over time, but we'll try our best not to. All right. N- No, so one of the question has popped in, so I'll just explain the answer to that. No, the will has to be made separately. It's better to make it separately because we don't know when one of us would pass away. And in that case, the will would immediately be executed. If the other partner is alive, then how would that be executed? So best to make your own personal will. All right, so moving on. Now we'll discuss in a little bit more detail about the witnesses. Islamic perspective, we can see this ayah from Surah Al-Ma'idah. So let's read that. O you who believe, when death approaches any of you and you make a bequest, then take the testimony of two just men. So you can take the as witness two just people among you, not those people who are known to be the major sinners. People who we know that they're not involved in many major sins and so on, you can take them as witness, and those two can sign. But in case you do not have two male witnesses available, then one male and two female witnesses can also witness the will. The process of witnessing. Present with two witnesses and identify to them that the document is your last will and testament. So they should know that this is your last will and testament, that's what they are signing. You and the witnesses must sign at the bottom of every page of the will while being together. It cannot happen like that you sign now and witness, and then you take it to witness one's home and get it signed, and then you go to witness two's home and get it signed. It doesn't work that way. If the will is contested, if your children or other beneficiaries go to the court and challenge your will that my father or mother did not give us the due shares in his or her will, they excluded me or gave me lesser than the others, they contest the will, then these things would matter. The court would see if it was properly witnessed or not. If it is found that the witnesses, both of them, were not present at the same time, the will might be null and void. You and the witnesses must sign at the bottom of every page of the will while being together. Sign and date the last page at the end of all the text. Now, the will document that you guys have received, it has got the places where all of you can sign. On every page at the bottom of it, you have got areas where the witnesses and the testator, the person making the will, have to sign. And similarly, on the last page, there's a place where you can put the date and so on. The witnesses should see you sign the will and then sign by themselves. So first you sign and then they sign. It is preferred that all of you should use the same pen, and that would indicate to the court that you are all present in the same setting. It's not a requirement by the law, but it's preferred this way, that all of you should use the same pen. Who can be a witness? A person who's able to see and attest that a testator has signed a document can act as a witness to will. So if someone is unable to see, then that person cannot be a witness. But if a person can see and attest that a person has signed in his presence or her presence, then that person can be a witness. A witness to a will can be anyone who is over 18 years of age and of sound mind. It is recommended that your beneficiaries should not be a witness. It's very important because otherwise there would be conflict of interest. So your beneficiaries and preferably your executors as well should not be the witness. They should be other third parties. And I briefly described about the definition of the executor, and I'll do that again later on. It is recommended that your beneficiaries should not be a witness in order to avoid any legal disputes. You should have people that your executor know as your witness. So this is important. In case the will gets contested, your executor, who is the person who's executing your will, should know who your witnesses are. Okay, let's take a pause and see if there are any questions. So Nasir bhai, are there any questions that I need to look at in the chat box? So Islamic age is the same age that which is in the law, like age of maturity should be achieved. So I would say 18 years and above, we should make the will. जी. जी बिल्कुल ऐसे ही.
Nasir bhai's voice is not
नहीं ये वो
audible.
बेनिफिशियरी में आ जाएंगी तो इस वजह से.
Nasir bhai's voice is not audible, so you can repeat the question and then answer will be better. Nabeel bhai, jazakallah.
So inshallah about the guardianship we'll cover later on. So there's a section on the guardianship. Humayun bhai, are you on both the meetings? Can you see questions from both the meetings? Okay, inshallah. It's better not to have the executor as a witness of the will, but just to avoid conflict of interest. We should try to be as safe as possible. Inshallah, we'll cover this in the topic of international wills, which should come shortly.
Also, can this will template be used in another country? Is there any requirement to register the will to?
We'll cover that later on, inshallah.
Or registered lawyers?
We'll cover that, inshallah.
Can we update a will time?
Yes, that's correct. We can, and that's the section that we're about to start. No, legally it's fine. Islamically it might be better, but legally it's fine.
If one witness dies, then we need to redo the will.
No.
Have this document verify? Okay, I think they are talking about the will template.
Mhm. Yes, we discussed with two of the legal experts. Yeah.
Nabeel bhai, we are not able to hear the questions.
The purpose was so that if there are any burning questions, we should just address them, and then everyone is on the same page. If yeah. All right, then. So inshallah, maybe we can pause here then, and then we can take the questions, rest of the questions later on, inshallah.
Brother, can you hear me? There is one suggestion. I think if you can use one screen and then so everybody can hear the questions as well, because we are not hearing
Let
the
me see.
questions. Sorry, this is.
Can any brothers in this other meeting confirm if they are able to listen properly?
So the questions are not audible. We can hear it faint sound.
All right, so
but it's
maybe
not
they
clear.
can mention in the chat box if they are finding it difficult.
ठीक है, questions को मैं अभी gather फिर भी कर लेता हूँ. We'll reconcile that in the end as well.
Okay, inshallah. All right, let's continue with this section about revocation of wills. So there are certain situations in which your will would become null and void. So in that case, we'll have to make the will again. So one of those situations is when you marry or when you divorce. So in most cases, when you marry, the will would be null and void, and you'll have to make it again. Unless there are a couple of conditions, but as those conditions are a bit complex, I won't go into that detail. As a simple rule of thumb and a simple thing to remember, we can say that when you marry, you have to make a will again. So also in case of divorce, you should make a will again. As per law, there are certain things which automatically drop from the will when the divorce happens. So it's better that you make a new one. Childbirth. So there are some will documents that basically list the names of the heirs or name of the beneficiaries inside the will. So if that's the case, and if you have done that, then you have to make the will again. But if you have not mentioned them by name, then it is fine, and you can your will will still be valid. So no problem with that. If not included as a beneficiary by name, the child can challenge the court. So there are certain things in which they can challenge. For example, if you mention, like if you've got 3 children and you mention names of all of them in the will, and then the 4th kid is born, and then that child would not automatically become eligible for the share. And then that child can go to the court and say that my father excluded me or my mother excluded me. So it's better we should not mention them by name. And in our will document, there is no space, no format available where you can mention the names. And that's the reason for that, so that we don't want our will to be challenged. All the eligible beneficiaries of the time, our children, our mother, father, etc., who we have described in Appendix 1 of the will, they can all get their share without being named. Now, this was a question from a brother. What if I want to change my will? So there are 2 ways. One way is that there's a thing known as codicil. It's a legal document in which you mention what changes you require to a will. You can either sign and lodge that, or you can make an entirely new will. If you make a new will, your previous will would automatically get revoked. So that's an easier way, and I would recommend making an entirely new will if you have to make any changes, rather than filing a codicil. So this is just as I mentioned, that a part or complete will would be revoked if you make a new will. You can also alter the will. And for example, in our will document, there are some things that you would need to alter. For example, in our will, we have mentioned about organ donation, and we'll come to that later on, inshallah. So if you do not want to donate your organs, you can cut that clause. And then what needs to happen is that you should sign next to it, and also the 2 witnesses should sign next to it. So if you make any change in the will, it has to be very clearly visible, very clearly readable that this is what is being changed. And then next to it, you should sign. You and the 2 witnesses should sign. Okay, so now we come to organ donation and autopsy. So generally, autopsy is disliked. So generally, as Muslims, we do not like our bodies to be cut open or dealt with in any way that can be culturally insensitive. So generally, autopsy is disliked, but it can be permitted under certain circumstances. So that is why in our will, we mention that our body should not go for autopsy unless if it's a legal requirement. In some cases, there is a legal requirement and government has to do that. So our scholars mention that if there's a legal requirement for something, then we have to fulfill that. So if that is the case, then we will allow our body to have the autopsy because it's a legal requirement. So generally disliked. Dislike means it's makruh, not liked, but it is still not a sin to do that. In Australia, the bodies are treated with respect during autopsy, so which is a good and plus sign, and can either be limited or full. So autopsy can either be limited, just maybe a particular organ or a particular thing, so that they can identify information from that and use it in future cases or for medical benefits. So in those situations, it's allowed. Now, these are some of the situations in which the government would ask for autopsy. That might include sudden death, or if a person dies because in a violent situation. So in those cases and some of the other cases that you can see on your screen, government would request for autopsy. I won't spend too much time on that because in case it happens, the family would automatically be notified about those things. And inshallah, you'll get a copy of this presentation and you can read through some of these situations in which autopsy would be required. So the action items in your will mention that autopsy should not be performed on your body unless it is unavoidable as per law. And this is what we have already built in for you. Now comes a topic which is very dear to my heart. We can move on the slides. Organ donation. So Islamically, there are 2 perspectives. So perspective 1 is that, and I'll share both along with the evidences. Perspective 1 is that our body is the amana of Allah subhanahu wa ta'ala. And in the same manner as our wealth is amana of Allah subhanahu wa ta'ala. So what Allah subhanahu wa ta'ala has entrusted us with, we should use it for the benefit of the mankind. So Allah has entrusted us with wealth. We should use it for the benefit of the mankind. Allah has entrusted us with the organs in the body. We should make them used for the benefit of the mankind, even if we die. So based on this, a number of almost all scholars in Middle East, they permit organ donation. And it's not just Middle East, the Islamic Council of Victoria and also Australian National Imams Council. They also approve organ donation and in fact consider it liked. Why is that? It's basically necessity, because one of the principles of fiqh, one of the principles of Islamic jurisprudence is that when there is a need, when there's a necessity, then things become permissible. Even if it is considered as impermissible, when there's a necessity, it would become permissible. Just like in case of necessity, you're allowed to drink alcohol if you're gonna die. You can have a morsel of some haram food if you are going to die. So accordingly, if your brothers and sisters are dying because they don't have the organs in their body, their liver is not working, their kidney is not working, their eyes are not working, they need that, and you take them to your grave, and it all become part of dust. So in those situations, our scholars say and even recommend that we should give the organs, we should donate the organs. So that is one perspective. The second perspective is that we should not donate the organs, and that's the perspective that is held by most of the scholars in India and Pakistan. And those scholars say that there's a hadith which says that breaking the bone of a dead body is the same sin, same gravity as breaking the bone of a person alive. So they, on the basis of that, they do the qiyas that cutting the body and taking out organ of a dead body is the same as taking out organ of a living being. So based on this qiyas, they say that organ donation is haram. So as I mentioned, both the scholars have got certain evidences which they use in driving their ruling. I personally adhere to opinion one, that we should give organs because there are people dying. And with the organ donation, the thing is that it is basically based on the ethnicity as well. So people of East Asia and so on, they would never get the organ donation because we don't donate organs. Organs donated by other people would not match with them. And many people would die because of us. We had the capability, we did not give it. We prefer to get our body organs get converted into dust, and there was someone who was dying in the need of that body organ. So I personally prefer to opinion one, but you can choose whichever you think is closer to the Quran and Sunnah, and you can consult with the scholars of your choice and then take their opinion and follow that. So what I just mentioned is in line with what you see on your screen. It's aligned with the Maqasid al-Sharia. Though our Sharia has got some broader objectives. There are some broader purposes of that. So this is what the Deen came to preserve. So the first thing that the Deen came to preserve is the preservation of religion, the preservation of the Deen. This is what Islam tries to protect and preserve. Then comes the preservation of life. And it's a beautiful thing. So Deen takes precedence. That is why you sacrifice your life for the Deen. And then after life, intellect. So you have to preserve your intellect. And then your protection of lineage. And then protection of property. So wealth you spend in order to protect your intellect, in order to get treated. Similarly, lineage, Islam wants our lineage to continue. So anything that breaks our lineage, that, for example, not getting married and so on, Islam dislikes those things. So even if we start assessing all our decisions on the basis of these 5 things, we won't need anything else, inshallah. So we would be able to get guidance from the Quran and Sunnah if we keep these 5 things on top of our mind. So this is what scholars have come up with, that Islam basically tries to protect and preserve these things. So protection of life is a very high priority. So we are saving someone's life by giving or donating the organ. So that is why it's recommended and preferred. And I won't go into these individual cases, but there are many cases where people are alive because of the donations that people have given them. These little babies and these people in our community would not have been alive unless people had given them the organs. All right. So as I mentioned, in Muslim community, the organ donation is extremely low. And I think the people who are available today, this cohort, approximately 100 people, 50 in each meeting. So we guys can make a difference. So these 100 people can make a difference today. What is the process if you are interested? So you can indicate in your will that you want to donate the organ. And then there's an Australian organ donor register. You can go there and register yourself as an organ donor. Also, those of you who have got MyGov app or MyGov website account available, you can go there and also under Medicare, you can register yourself for as an organ donor. And then a card would come to you from which it can be identified that you are a registered organ donor. We have to keep one thing in mind, that we cannot sell our tissue or organs. So we can just donate them. We cannot sell them to someone. So what we have covered so far is the Article 1 in your will document. So as all of you have got the will document with you, so up till now, what we have discussed is enough for you to fill Article 1 of the will. What we are going to start now is Article 2. And that article in our will document deals with funeral and burial. So one of the purposes of the will document is that you can let your funeral or burial directions be known through that will document. So that's one of the purposes of that. And so in our will document, we have mentioned that we should be buried in our white shroud Islamically, according to the Islamic directions. And that is based on this hadith of the Prophet ﷺ, in which the Prophet ﷺ said that wear the white dress. Why? فَإِنَّهَا أَطْهَرُ, because it is more cleaner. وَأَثْيَبُ, and more tayyib, more good. وَكَفِّنُ, and give kafan. Fiha, in it, mautakum, your dead. So bury your dead in the kafan of the white. That is why we use this white clothing as a kafan or the shroud. Also, another important direction, asri'u bil janaza. That asri'u means that we have to hurry for the funeral. Now just think for a moment. If this is the direction of the Prophet, then sending the dead bodies overseas, does it comply with this direction of the Prophet ﷺ? So that's one perspective. It is not allowed. The second thing is that, in fact, there are numerous things that we have to consider in that regard. One thing, where we die, we have to be buried at that place. For example, those brothers and sisters who go to Medina, the shuhada of the Battle of Uhud, where are they buried? In that exact ground where they embraced martyrdom. How far was Medina, Jannatul Baqi? 10 or 12 kilometers away from that. But they were buried at that place. Even that much traveling was not done for them. So that is basically our way, that we have to bury where we die. It's not Islamic that we send up dead bodies overseas. And also later on, I'll show you what else is wrong with that. Okay, now this is another important thing. If a man dies, if a woman dies, then her husband or brother or male guardian has to pay for her funerals. So because it is your responsibility as husbands, as fathers, as brothers, it's your responsibility to pay for the funeral of the women. But if a man dies, then it is not obligatory upon women to make the expenses for his or his funeral, because man is not a responsibility of women. So in that case, it would be taken out of your estate. Your wife doesn't have to pay for that. And that's how Islam protects the rights of the women. That's the status that Islam gives to the women. As man, you are responsible for them, but they are not bound, they're not obliged to spend on you. If they do that, that would be sadaqah on their behalf, but it's not obligatory upon them. Now, this is a thing that we should all strive for. The effort of iCAN is for this purpose. We want our janaza to be big. We want more and more people to come to our janaza. That is why we do the community service. That is why we serve people with our heart, because our beloved Master Sallallahu Alaihi Wasallam, our beloved Prophet Sallallahu Alaihi Wasallam has told us, if a Muslim dies and 40 people who do not associate anything with or anyone with Allah in worship participate in the funeral prayer over him, Allah will accept their intercession for him. And this is the hadith from Sahih Muslim. So if 40 people pray in the janaza, and these are the people who are not the people of shirk, they do not associate anything with Allah subhanahu wa ta'ala, then that dead body is, Allah subhanahu wa ta'ala would, inshallah ta'ala, forgive that soul, inshallah. The next hadith says, any Muslim who dies and 3 rows of Muslim make salah for him, he will be forgiven. And again, this hadith is found in the Sunan of Abi Dawud and so on. So that is what our aim should be, that we should be so much engrossed in community service that when we depart, people really feel that they have to go with our dead body to let us move into our next life. So if we engage ourselves in that service, and if we are able to make that impact, inshallah, we are doing it for our own good, for our own akhirah, inshallah. So we should all aim and try to do for that. And this is an answer that I heard from one of our brothers. Someone asked him that, why did you join iCAN? And he told, because I want my janaza to be bigger. These are the words that he said. What brave and beautiful words are these? All right, now we'll discuss briefly about the disposal of body, different methods. So one of the methods which is most widely used in Australia, and it is the cheapest method, it is the most cost-effective method, it is cremation. What do they do in cremation? Just like how they bury the dead in India, they also bury the dead, but in a chamber. And then the dead body is converted into a form of dust. And then they do different sort of things with that dust. But Islamically, it is not allowed. It is as if you're burning a person alive. Islamically, as per the qiyas that I already mentioned, it is as if you're burning a person alive, which is Islamically not right. So you cannot burn the deceased. The second form, which is Islamically approved and Islamic practice, is the burial of the dead body. The third one is embalmment. What is embalmment? Embalmment is injecting certain chemicals in our body to preserve it. Or in other words, or simpler words, you can say mummification, just like the ancient Egyptians used to do. So they can insert certain chemicals in our body so that the body remains preserved. Now, none of us, no one in this community or this society is going to make mummies. But where do they use embalmment then? They use embalmment so that the burial can be delayed, so that all the relatives and so on can come, so the burial can be delayed. From the hadith of the Prophet ﷺ that we saw, that we have to hurry for the janaza, then accordingly this is not allowed for us. Similarly, if we have to send the dead body overseas, many a time I see on various groups and so on that funds are being collected to send the dead body to Pakistan or to other places. How do they send? There are 2 ways of sending it. One, they have to send it in a refrigerated container, refrigerated aircraft, which is extremely expensive. The other is that they embalm the body, inject certain chemicals in the body, and then it goes overseas. Both these practices, according to my research, are un-Islamic, and we should bury the dead where they die. The third practice is burial at sea. And as you can see that there is a yellow mark with that, neither green nor red. It means that it is makruh and it is permissible in certain situations and certain circumstances. For example, the people who die at sea. So those dead bodies can be put into the sea, burial at the sea. It can be done for them. Burial expenses. So according to the fatwa of the scholars, the first expense that has to come out of our estate, whatever we have left behind, the first expense that has to come out is our burial expenses. And according to reports, there's consensus of scholars on this matter. What's the rationale for that? as our own clothing. If someone is in debt and he has to pay the debt and he doesn't have clothing, so his buying of the clothing would take precedence over giving away the debts. And the same, they say, is applicable for the diseased as well, based on the chaos that I mentioned earlier, that breaking the bone of a dead person is as if breaking a bone of a person who's alive. So it means that there's a similarity or parallel relation between the two. So they say, according, just like how the alive person has to get the clothing first, similarly the dead person, his coffin and shrouding comes first, and then the debts. So first thing is fulfilling the legal responsibilities, and then we should settle the debts, because if we don't settle the debts, there is very strong punishment for that. If someone dies with debt on his shoulders or her shoulders and that is not paid off, there are very strong warnings regarding that thing. The soul of that person remains suspended. The soul of that person remains suspended till that loan is paid off. Such a grave thing, that your soul will not be able to reach its destination. It would remain suspended till the loans are paid off. The Prophet ﷺ did not use to pray the janazah of those people whose debt had been unsettled. So companions used to immediately settle the debts for the deceased, so that the Prophet ﷺ would then pray for them. And then we have to wash the body according to the Islamic principles. And that process is not a part of this workshop, because this workshop is mainly for wills. So inshallah, in another workshop, we can cover the fiqh of janaza, how to do things, when to do things, what is the prescribed ways, and so on. So you have to wash the body, shroud the body, offer the funeral prayer, and then starts the burial process. One of the important things to consider is that when the person dies, we should contact the authorized organization and funeral directors for organizing the funerals. Not everyone can organize the funeral or the burial. So there are authorized organizations. I'm not sure about who deals with that in NSW, but your people in your locality and our brothers in iCAN would know as well. And inshallah, they would be able to help you with those organizations. Also, Islamically, there should be no extravagance in the takfeen and the burial. And we have put this as one of the conditions in our will document, that there shouldn't be any extravagance. We shouldn't have any decorated sort of the coffins and so on. We should try to bury the body within 24 hours, because our beloved Prophet ﷺ said that we have to do surah. We have to be very fast and hurry in the janazah. Otherwise, there would be cost, and those who are alive are more deserving of money being spent on them. And there's a very beautiful saying about Abu Bakr Zitala. So he already dedicated or reserved the shroud that he would have as his coffin. And it was one of his old clothes that he used to have. So he said, bury me in that cloth, because those who are alive are more deserving of the new cloth. Bury me in my old cloth. And that's what we should do as well. No extravagance at all, not even buying the new coffin. So if you have a cloth that you have used before, maybe your ihram and so on, use that rather than new cloth. But if it's a modest new cloth, it's not prohibited in Sharia, but no extravagance is required. Now, this slide, I would mention that this is basically what is applicable in Western Australia. And I didn't have a chance to research about New South Wales on this topic. In Western Australia, there's a requirement that the body has to be buried in the coffin. And the coffin cannot be opened once it reaches the cemetery. So it has to be closed. It cannot be opened once it reaches the cemetery. Now, what's the Islamic ruling on that? The Islamic ruling of that is twofold. In some situations, it's makruh. In normal situations, it's makruh. Makruh means it is disliked. Dislike means it is not a sin to do that, but it's better to avoid that if possible. But if you do that, there is no sin. So that's the ruling for that. But in some situation, it is allowed or even recommended And those are the situations when, for example, the body is burned. If the body is burnt, then it is recommended to use the coffin. So that's the ruling for that. So summary of that is that there is no harm, no sin if the body is buried in the coffins. With regards to the payment of the funeral, some bank can release the payment for the funeral. If you show the death certificate and so on, they can sometimes give the payment from the account of the deceased for modest funeral expenses. Also, some health insurance and so on, they can also give some advance payments and so on for the funerals. From the government also, there is a bereavement payment, but the circumstances and situations change. So at the time of death of the loved one, this is a payment which probably is available from the government. All right, so what are the action items for this section? Keep all your personal details, including the birth certificates for children, marriage certificate, etc., in one place, because it would be the nightmare. Like in case of death, all these documents are being searched for. It would be a nightmare. So all these important documents should be kept in one place. Your spouse, your executor should know about them. Keep all your accounts, investments, and super information handy so that the next of the kin and the beneficiaries and executors should be able to find them. And if I discuss with some of you in the room, I'm 100% sure that I would come to know people whose assets their spouses and executors are not aware of. You might have a plot somewhere or piece of land somewhere, and your executors, your spouse, don't know about that. Similarly, there would be sometimes spouses don't know where our superannuation account is, which company it is. So we have to keep all that information in one place so that our executors can easily find that. None of us know when our final time is. None of us know when would be our last moment in this world. So we should not wait for a particular time or particular year or so on. We should do it straight away. So up till this point, what we have done is that we have completed section 2 of our will document. Now we are starting with section 3. And this section is one of the most sections. It is about the executor. And as I mentioned earlier, executor is the person who would be executing our will. Now, at this moment, I'll take a very little pause and I'll ask just one person from each meeting to just let me know if the pace is going fine or if it's going fast, or if you are finding any difficulty with my style or with my pace or delivery and so on. So you can let me know so that I can adjust it in the remaining 1 hour that we have. So one of the brothers from one of the meetings says that this is fine, inshallah. And can someone, Rashid bhai, can you maybe let me know if everyone is fine in this other group as well? Or Zia bhai?
Yes, I think it is okay.
Inshallah. So brothers in both the groups think that the pace is fine. So inshallah, we'll continue. If you have got the will document in front of you, inshallah, we have now the article 3, which we are going to discuss, the executor. So as I mentioned, executor is the person who would execute our will. So whatever we write in the will, executor is the person who would distribute it according to our will. So who is an executor? An executor is a person you appoint in your will to carry out your wishes when you die. What do executors do? They deal with your estate. An estate, if you remember, I mentioned, it is whatever you leave behind. Your accounts, your plots, your house, your car, your factory, your shares, that is all your estate, whatever you leave behind. So they deal with your estate, paying your debts. They can make financial transactions on your behalf and distributing your assets to your beneficiaries as set out in your will. An executor is sometimes also called the personal representative. Who can be my executor? An executor can be anyone who is over 18 years of age and who is trustworthy, because these are the people to whom all your belongings would get transferred to you. The house, the account, the car, the factory, everything would be in their hand, and they would be the ones who would distribute it. So it has to be a very, very trustworthy person. So who's the most trustworthy person in your life and who's most closest to you? In most of the cases, in 99% of the cases, it would be your spouse. So that is the best executor. Appoint one or more executors. Why is that? Because it can happen that executors can also pass away before us. So that is why it's important to nominate multiple executors. If you appoint two or so, and then there are different ways of appointing them. One way is that you can make them as joint executors. It would mean that whoever you have nominated, all of them would have to take the decision at the same time. All of them have to agree for a decision to be made. For example, you can say my wife and my son, who's an adult, they would be the joint executors. Both of them would have to agree on a thing, and then the thing would be executed. Or you can also nominate them jointly and severely. That would mean that either your wife can take decision or your son can take decision, any of them, if you have mentioned them as jointly or severely. But it's not necessary to have joint executors. You can just have one person as well. And then if that person passes away before me or doesn't want to be an executor, then that person or that person. So you can nominate individual people as well. Now, sometimes you can also pay certain fee to the executors. So if there are some government bodies as well, if you make them your executors, like public trustee, then they take certain percentage of your estate as their pay or their salary or their fee, and then they would execute the will on your behalf. But better solution and easier solution, in my opinion, is that you nominate your spouse or your relatives or your trustworthy people, and they can execute. And as it would require some time from them, they would have to deal with your house, accounts, government, Supreme Court, and so on. So if you want, you can give them some percentage of the estate as a salary or as a fee. So Islamically, inshallah, it is fine as well. What to consider when selecting the executors? Things you should consider include how likely they are to outlive you. For example, if you're 40 and you select someone who's 60 years of age as your executor, the chances are that they might not outlive you. So think about their age, that would they outlive, are they likely to outlive you or not? Will they have time and motivation to do that? For example, if you select someone who doesn't have any knowledge of any legal matters or can't even read English or understand English, then it would be very difficult for them to make these legal decisions. So their motivation, time, skill, how impartial they would be in case of a dispute, do they have some understanding of your assets and so on. So all these things you should consider. Now, I won't through all these documents because inshallah, this presentation would be shared with you. But the purpose of it is your executor, if you don't give them the necessary information, they would be in the dark. They wouldn't know where your accounts are. They wouldn't know where your plot is, where's your piece of land. They wouldn't know which companies you have got shares in. How would they find out? So you have to make a register of all your assets and give it to your executor and keep updating that regularly. So that all the current details are available in there. So make a register and give it to your executor, which would ideally be your spouse, and then keep it updated. Or at least let them know where you are keeping it if it is not available with them. All right, now the main duties of the executors. What do they have to do? Pay the funeral expenses, taxing, and other debts on your behalf. Obtain the death certificate from the hospital. Inform the relevant organizations about the death. Obtain the authorization to manage the estate to execute the will, called the grant of probate. Secure the assets. All the assets would come to them. And for that, they'll have to go to the relevant organizations, show the grant of probate, and then they would transfer the assets to them for distribution, which they would be legally bound to distribute as per your will within 12 months. File any tax returns. If you die without filing the tax return, it still has to be filed even if you die. List all the assets and their value. Seek advice in doing so as required. If they need legal assistance or financial accounting help, they should seek that. Discuss with the beneficiaries if they can agree on assets that can be distributed without selling. And this is very Islamic. This is Islamically the case as well. For example, if you leave a car and if you leave cash of the same amount, so the beneficiaries can discuss and agree with each other that one beneficiary can say, I'll take the car and I won't take anything else. And other can say, okay, you take the car, I'll take the cash. Or one of them can take the factory and forfeit any other things that might have come to them. So they can discuss that. Establish the trust in accordance with the will and legal requirements. So park this point for a time being. I'll tell you what trust is later on. And their responsibility is to distribute the estate according to the will. Estate is what you leave behind. Prepare the final account showing all the payments. So they have to do an accounting of your estate as well. What were the initial assets that you left? What was their pricing? What was your condition of giving or disposing of those estate? Who did they give it to? All these accounting details they have to make and then submit then that in accordance with their grant of probate to the Supreme Court. Complete and distribute the estate within 12 months after the grant of probate. Best executor, as I mentioned, it's your wife. And once you die, or once we die, our children, our spouses would be deprived of any money that we are leaving behind. So it would go to a third person. It would go to, if your wife is not your executor, it would go to someone else. So from where would your kids get their share and their maintenance allowance and so on and so forth? So it's best that we give it to our executor, and that executor can do the record keeping. That you say that certain percentage as Islamically required or applicable is going to my wife. So you know that she's got a share and your children have got a share, then she can spend on them and keep a record of what is being spent. And then that would be submitted according with the completion thing. If there is no will, who can be the executor? If there's no will, then there are certain people who are the beneficiaries, like your son or your wife or your daughter. These people can request the grant of probate, which in this case would be called the grant of administration. They become the administrators, and then they can administer the estate on your behalf. What happens if my executor dies? You nominated someone and that person died, or otherwise is not interested. So whoever is next in the line, so you mentioned 2-3 different executors. If one person dies or is not available, the next person would kick in. So that way it would manage. And if suppose all the executors die, then this last point is applicable. If the last surviving executor of your will dies after the probate, your will has been granted, the executor of the deceased executor will take over the administration for both your estate and his estate. So that would be a bit complex, but if you have got 3 or 4 people, generally at least one of them would outlive you. Action items: appoint more than one executor. The first of them should be preferably your spouse. Mention that executors should be able to serve jointly or severally or independently, individually. Specify any fee for service that you wish to give to the executor. So you can say my spouse would be my executor, and every month this much $5,000 or $3,000 or $2,000 from my estate, I'll pay to her as expense for her services as an executor. Discuss with your spouse and adult children about the responsibilities of the executor. So this is when you write the will. Educate your children, educate your spouse that it's not a simple process. They have to understand these things, because when the calamity befalls, it would not be the best time to learn. So the best time to learn is now. You educate your wives and children about these things, especially your daughters, about their shares and so on. Because most of the times in Muslim families, it is the daughters who challenge the will. So we have to educate them. Islam has prescribed certain shares. Why is that? Why is that? And then with logic, you have to explain to them that in Islam, we give meher to the daughters. Also in Islam, gents, the males are responsible for all the expenditure of the women. So they have to organize their marriage, they have to organize their funeral. If any one of them does not have any husband and so on, then we have to take care of them. All these things are the responsibility of men. So you men get more share, but they have to spend more out of it. But women, whatever they get, they are not obliged to spend anything out of it. That's completely theirs. So these things have to be told to our daughters in the best manners. Who approves the executors and the administrators? So it is the Supreme Court. As I mentioned, through these different types of letters, they approve. So probate, in case you left a will and there was an executor in that, an executor is alive, they would go and get the application for probate. And then letter of administration, if there's a will, but the person does not name an executor in that will. So someone can, if one of your beneficiaries can request the letter of administration. If even that is not the case, you don't have the will, then in the same case, same manner, any other beneficiary can request the letter of administration. How to apply for probate? So you go to Supreme Court, there are certain documents that you need to fill, you have to provide them with certain documentation and so on, and then they would do that. In New South Wales, there's a special requirement, and that special requirement is that you have to lodge your intention to get the grant of probation, the grant of probate from the Supreme Court, and there's an online registry for that. So you do that, they advertise it for you for 14 days. And after 14 days, then you can put the application through, and they take 4 to 6 weeks, depending on how busy the court is. And then they would give you the grant of probate. And then you can start your function. And whatever we discussed before, you secure all the assets and so on. And then you start distributing in 12 months and maintain full bookkeeping and accounting of what you got and what you disposed of. Requisition. Again, we won't go into much detail. Requisition is the thing when court requires more information from you. If they require some more information from you for something, then this is called a requisition, and we won't go into much detail of this. So action items for this section: keep the relevant documents handy to smoothen the process. Your executors should not be searching for those documents. Understand the process well. It's documented in this presentation. You can go through that. You can also see the government websites. You can talk to the lawyers and so on, and inshallah get more guidance. So with this, we have now completed Article 3 of our will. So those brothers who have got the will document in front of them, so far we have completed 3 articles in that. Now we are going to move to Article 4 of our Islamic will. And that is about arbitration. What is arbitration? Arbitration is if a conflict arises. In that case, if a conflict arises, you can nominate a neutral person, maybe an elder in the community, maybe a knowledgeable person, maybe a scholar, maybe a representative of a charity organization or an Islamic organization. You can nominate them as arbitrators. So if a dispute occurs, they would help the parties resolve the dispute. So we have included a clause of arbitration in our will as well, and you can nominate who would be the person to decide in case an arbitration is required. In your will, you can mention that. Now we come to the topic of the guardianship. It is again a very important topic. If we die and if you've got young children, and the court would then send them to certain people, certain foster parents who would take care of them. At this moment, I would take a pause and ask you, how many of you have shown interest or registered to be the foster parents? If Muslim community does not register to be the foster parents, who would our kids go to? If there's a need, who would our kids go to? So it's very, very strange that many of the Muslim kids have to go into non-Muslim families, because our families are not willing to be the foster parents. Whereas it is the sunnah of our beloved Prophet Sallallahu Alaihi Wasallam. The orphans, the people who needed the foster caring were in his house. Zaid was in his house. Anas did spend years and years with him. So he was a foster father. So what are we doing? Are we following the sunnah of our beloved Sallallahu Alaihi Wasallam, or are we just following our culture and so on? So this section would deal about the guardianship. So appointing a guardian. A guardian is someone appointed to exercise parental responsibility for a child who's under the age of 18. So in Australia, anyone who's under the age of 18 is considered a child. So for that, guardian has to be nominated. A guardian is appointed in two ways, either by parents' will or by court. So it's important that we should identify the guardians in our will. If none of the parents is alive, nomination of a guardian through will of one parent cannot take effect in WA. So if one of the parents is alive, for example, if a husband dies, then wife would become the guardian. But if none of them are alive and they both of them nominated different people, then there would be a conflict and dispute. So then the court would decide who the child would go to. So best is that you make your will in consultation with your wife and agree on who would be the guardian. Now the question is, why to appoint a guardian? What happens if you don't appoint someone? Can your parents from Pakistan or maybe from Bangladesh or India come and become the guardian of your children? The answer is unfortunately no. In many cases, no. In some cases, yes, but in many cases, no. Because court is or the government is very much concerned about the well-being of your children. The government does not want your children to be exposed to poverty. If they're able to live here in good circumstances and good financial condition, and if there's a probability that overseas they would be suffering in some way, either financially or emotionally or any other way, then the court might say that even though the relatives have come, the foster parents would be allocated locally. So it's important that we should have someone local in our list of guardians as well. And in our will document, we have got section where you can nominate multiple guardians. Maybe if you've got a brother who is having a similar financial status, maybe living in Canada or UK or elsewhere, you can nominate your brother or sister as well. You can nominate someone locally, and then you can, if there's no one else trustworthy, then you can nominate someone from overseas as well. Death of a guardian. What happens if the person I have appointed as a guardian of my child dies or is unable to become a guardian? If this happens before you die, you should write a new will. If it happens after the will, then court will have to determine who looks after the children as their guardians. So, action item for us, we should nominate the guardian for our children in our will, for which we have got this section, which we have just discussed. Also nominated some backups, because it can happen that the guardian may pass away during the guardianship or before the guardianship is given to them. So have multiple people nominated as guardians in a hierarchical manner. Try to nominate local guardians for the reasons that we just discussed. Discuss with your guardians beforehand so that later on they don't say that, no, I don't want to be a guardian. So discuss with them that I'm nominating you as guardian. Are you willing? Are you accepting? And let them be mentally prepared for this task. So Alhamdulillah, we are done with Article 5 of our will. And now we are going to discuss the Article 6, which is about debt. Brothers, we have got 35 minutes left, and it seems as if we might run a little bit over time. So I'm just mentally preparing you, maybe 15 minutes, if you guys can stay. Otherwise, if there are any brothers who have to leave after 2 hours, then they can watch the remaining part through the video that we have that is available on our Facebook page from a previous session. But inshallah, if you want to stay in today's session, it might be a little bit over time. So starting with debt. So I won't go into a lot of detail on this one because some of it we have already discussed. First expense, whatever we leave behind, the first expense that has to go out of it is takfeen and tadfeen. We know what these terms mean. Takfeen means shrouding, and tadfeen means the burial. So these two expenses are the first. Then you have to pay the debts. It's extremely important. We had to get our soul free. We have to pay the debts. Then comes Al-Wasiya. What is Al-Wasiya? Al-Wasiya is bequest. Bequest is what Allah subhanahu wa ta'ala has allowed us to give as gift to certain people. And those people should not be the ones who have got the given share of inheritance for whom Allah subhanahu wa ta'ala has already determined the share. For example, I cannot say that my wife would have X share for my inheritance, what Allah subhanahu wa ta'ala has prescribed in the Quran, plus I also give to her 33% of my wealth. It cannot work that way. So non-beneficiaries, you can give them in wasiya. For example, you can give it to any charity organization, you can give it to any dawa organization and so on, you can do that. And then whatever remains, and it is not a requirement that it has to be 33%. It can be anywhere from 0% to 33%, but not more than 33%. 0 to 33 is allowed. And whatever is the balance after that, then it is what is distributed in certain percentages as the estate that goes to our beneficiaries. All right, so this we have already explained. I won't go into the detail. This hadith I have already explained to you. So just like this again on the next slide, we have got further evidence that on behalf of the deceased, certain obligations have to be still fulfilled. For example, if someone made a vow, it has to be fulfilled and so on. So same is the case with the debt to Allah subhanahu wa ta'ala. So just like we pay the debt to people, we also pay the debt to Allah subhanahu wa ta'ala. Like zakat, if it is not paid, we have to pay from the estate. So whatever we discussed before was what was legally one obliged for. So that is what we discussed. But ihsan is that not to take it from the estate of the disease. Legally, Islamically, we can take it from whatever the deceased, whatever the testator has left, we can take it from his or her estate. But ihsan means going above the minimum standard level. So for example, going above the passing marks, that is ihsan. If you meet the passing marks, if 60 marks were required to pass and you get 60 marks, you are passed. It is called adl. You just balanced it out. If you go below that, it's zulm. And if you go above that, it's called ihsan. So ihsan is that the government should take care of it, as the Prophet ﷺ did in his times. Or in the current situation which we are in, there's no government which takes care of it, then the community should try to do that. Community should establish a fund, especially in Australia where the burial, etc. is so expensive, then maybe as community we should have funds, we should have charity organizations who can take care of this aspect. Legally, any debts that you have while you are alive remains as debt. But once anyone who can prove you owed them money can make a claim from your estate. This will happen even if you don't mention the debt in your will. So even if you don't mention it, automatically it would happen. So they can go to the court and say that this person has to give me this much debt, and they can get it. Now, this point is very critical Islamically. If your estate is less than the debt that you owed, for example, the debt was 50,000 and the value of your estate is 20,000, then what would happen is that all your estate, $20,000, would go to the people who gave you the money, but 30,000 of their money would still remain. Legally, you're not responsible for that. Legally, your heirs and your children are also not responsible for that, but Islamically you are. All those things that we discussed about debt would still be applicable for you. Islamically, you are not excused from that. So your soul would still be stuck and held muallaq between before going to its final destination. So it's important that we should try to pay off the debt of people. Tax on estate is also applicable. So executor has to lodge the tax return for any remaining tax returns that you had in your life and also for the estate. So action items, as I mentioned, you should make a list of your assets. In the same manner, you should make a list of your liabilities. Your executor should also know about your liabilities, just like he or she should know about your assets, so that when you die, your soul is not stuck. It can reach its destination. If there are not enough funds, request the person distributing your estate to request the community to pay off the debt. Legally, they are not bound. But as we are Muslim community, our executor is Muslim, we should tell them, if I've got more debt than I've got in my estate, request the Muslim community to pay off my debt. This is for what we should be gathering the money, gathering the funds, not for sending the bodies overseas. Also include directions regarding any unfulfilled responsibilities towards Allah subhanahu wa ta'ala. Like if you have to pay the fidya for the mispast, or if you have to pay the zakat, those things also have to be paid. So alhamdulillah, we are completed with Article 6. Now let's go to Article 7, which is about bequest. Now, Islamically, there are two terms which we have to understand. One thing is called irth, and the other thing is called wasiya. Wasiya is bequest, for which I mentioned to you, it is between 0 to 33% after you remove your debts and after tadfeen and takfeen. Whatever remains, 33 up to 33% of that you can give to certain recipients. And is what is inheritance, for which the shares have been ascribed by Allah subhanahu wa ta'ala and his messenger. So these are the two terms that we have to keep in mind. Difference between wasiya and irs. And this is the term from which we have got miras, and we have also got mawarith, and all those sort of things, they come from irs. So in English, we can just say will. But in Islamically, we know that there are two components of will. One component of it is wasiya, and the other component of it is irth. So up to 1/3 of your estate after debts and tadfeen and takfeen, you can give in wasiya. And for irth, they are given shares. This is what we have already discussed. So who can you give bequest to? You can give it to your needy relatives. You can give to any deserving pious persons who are not already your beneficiaries. You can also give it to worthy causes like iCAN or other Islamic organizations and Dawa organizations. It is mustahab to give above. It's not mandatory. It's not essential. And if there's a doubt that your children would be poor after you, then it's better not to do any bequest. It is one of the companions was about to die, and he asked the Prophet ﷺ that I want to give all my possessions in the way of Allah subhanahu wa ta'ala. And the Prophet ﷺ said, the mafhum or the approximate meaning of which is that do not leave your children poor behind you. And then he kept on decreasing. And then after 33%, it was the amount which was allowed to him. So we should not leave our children poor, but giving 1%, bequest is not mandatory. It's optional. As I mentioned, you can choose between 0% to 33%, any number between that, 1%, 2%, 0%, whatever you like. So you cannot give it to your legal heirs, and you cannot give it to un-Islamic causes. For example, you cannot say that give it to whatever un-Islamic business or un-Islamic charitable cause it is. You cannot give it to that. Now, the importance of that. So we all know that when a man dies, all his good deeds stop, except for the continued charity, except for sadaqah jariyah. So that is why it's important. That can be our last little bit that we can gain the benefit from before we depart this world. Man goes with three things to his grave: assets, relatives, and his deeds. Assets are distributed among the people. Relatives put you in the grave, put dust on your face, and they go. And then you are just left with your deeds. So this is your last opportunity to get some good deeds from what provisions Allah subhanahu wa ta'ala had given you. So let's make benefit of it. And if there's no risk that our children would be poor after us, we can make some bequest. Similarly, once the Prophet ﷺ sacrificed a sheep, and Aisha Radhiyallahu ta'ala, people used to come and she used to just donate everything to the people that were coming in and taking their share. And then the Prophet ﷺ asked that what is left of the sacrifice? And Aisha Radhiyallahu anha said that everything is gone except one shoulder, a piece of shoulder. So the Prophet ﷺ said that everything else is preserved except this shoulder. The mafhum of a hadith is this. The hadith is on your screen. So whatever we give in the way of Allah subhanahu wa ta'ala, that is preserved, not what we leave behind. So if you are in a position where you can make a sadaqah, where you can make a donation, do that. Do the bequest if you've got the capability. So some of the recipients could be Islamic Dawa organizations like iCAN, Orphan Care like Al-Khidmat and other organizations, universities, the Islamic University, which inshallah ta'ala we have got an aim to make, and inshallah iCAN from iCAN's platform and also other individual initiatives, inshallah we have got an aim to make an Islamic university which would deliver top class Islamic education and make top class scholars, not just the scholars who are only indulged in the deep studies of fiqh. We want holistic scholars who can understand Islam as a way of life, as a system of life, its economic system, its social system, its political system. We want scholars to have this holistic understanding of Islam. So still those sort of universities are yet to be built. So inshallah, we've got a name for that. Islamic schools, mosques, hospitals, book writing. Alhamdulillah, from iCAN's platform, we have written 16 or 17 books. So, but we mainly publish them as ebooks because publishing them as physical printed books requires extensive expenses. So if, for example, any brothers would like to maybe sponsor printing of those books, or maybe in their bequest, they can mention that those funds can go towards this cause. Teaching, training, relief work, and so on. They can be numerous causes. All right, now after we have given our tadfeen and takfeen, we are now done with the debts, and whatever you had mentioned in the bequest has also been paid. Now what remains after that is called the residue or residual estate. So this is how the distribution of that would happen. So one thing Islamically we have to, so now this is the section which I'm going through now. This is the section about which I got the ijaza. All the other things I have done extensive research on, attended various lectures, various workshops conducted by various people and lawyers and so on, and then came up with those things. But this thing in itself is a huge topic. So I discussed with Nasir Bhai, and I told him that if any brothers are interested in doing that, we cannot cover it in this session, but we can have a separate session and we can attempt to cover that in 4 hours. So if there are any brothers are interested in how to actually calculate the shares, then we can have a 4-hour session and do that, inshallah. So one of the things in that is called mane irs, the things which would eliminate someone from being an inheritor. So one of those things which eliminate people from inheriting from someone is if they kill them. For example, if a person knows that if I kill my father, I'll get X amount from his wealth. So if a person kills his father with this intention, or another person for whom he's a higher, then that person cannot receive inheritance from that Islamically. Similarly, inheritance between the people of different faith is not allowed. A non-Muslim child, unfortunately, this is the case with many families. Their children are no more Muslims. Non-Muslim child cannot inherit from Muslim parents. Similarly, Muslim child cannot inherit from non-Muslim parents. So people from different faiths cannot inherit from each other. So that is another mania irs. So another thing that stops or becomes a hurdle to the inheritance. So now if there's a non-Muslim son or daughter, can you pass inheritance to them? So as we discussed, our inheritance has got 2 components. One component is Wasiya. The other component is irs. So irs they cannot have, because we are discussing about mane irs. Those things will become mane for irs, inheritance. But Wasiya, it's not a mane. So if you want to give something out of your Wasiya, you can give them. Some percentage of the share, you can give it to them. All right, now this is the thing which requires some extensive study. So there are 3 types of people who can inherit from your estate. Now we're not talking about Wasiya, we are talking about irs, inheritance. So these 3 types of people can inherit from you. First category is Zawil Farais. These are the people who have been allocated certain shares, very clear shares in Quran. And there are some which the Prophet ﷺ has clarified through ahadith. So These are the people for whom the clear shares are known. So these are called Zawil Farais. First of all, we will see that how much is the share for the daughters, how much is the share for the mother, father, wife, and so on. So their shares are very clearly distributed, very clearly defined. So first of all, we give it to them. Then comes Asaba. Asaba stands for the family. In this case, it stands for the residual hires. For example, you give, so what happens is that you give to your daughters, your mother, your, sorry, not daughters. You give it to your sisters, mother, father, wife, spouse, and so on. And then whatever is residual then goes to this category. And this has got sons and daughters included in that. So sons and daughters are one category. If there are no sons and daughters, then other male relatives comes in certain order. So that order is also prescribed in the book, and we won't go through that detail now. And if there's someone who doesn't have any asaba, those relatives who are defined, if he has none of them, then that inheritance would then go to the next category, which is Zawil Arham. Arham means, like Zawil Arham means the close relatives, the other relatives. If no asaba, then it goes to Zawil Arham. And if someone did not have anyone, not even any relative, no Zawil Arham, then his assets or his estate would become number 4, would go to number 4, which I think you cannot see on your screen, and that is the Baitul Mal of the Muslims. So then it goes to the Baitul Mal of the Muslims. So these are the 4 categories, and as I mentioned, if you need more detail of that, there can be a 4-hour session. And even if there are few brothers, even if there are 5, 6, 7 brothers, I'm happy to do inshallah session with them. These are some of the shares. Again, I won't go into the detail, but at this moment, I will just explain one thing, that in the appendix of your Islamic will document, you have got all these shares mentioned. And these shares depend on the scenario. Like, for example, if you have got wife and only daughters, then what would be the share of the wife? If you've got wife and sons and daughters, what would be her share? If you've got parents and you've got children, what would be their share? So it depends on the situation. So Appendix 1 of your will document summarizes all those different types of scenarios that are possible. So whatever the scenario, based on that, certain shares are mentioned in that, Islamically calculated. All right, now there is a special condition that we have to mention with regards to New South Wales. That is not applicable in WA, but I was going through the Succession Act 2006 today, and this condition needs to be added in the wills that are being made in New South Wales. Islamically, if someone dies after us, if someone dies after we die, then we have to pay them inheritance, Islamically. And if that person dies shortly after we die, then their beneficiaries would get their estate. For example, if I had a beneficiary X, and after I die, beneficiary X passed away very, very soon before we could transfer the share or inheritance to them, then the beneficiaries of Mr. X would get our share. So Islamically, that has to go. But in the Succession Act, from what I understood, it mentions that if someone dies in 30 days after, in less than 30 days after you, then it would be considered as if they died just before you. So law says that you have to include a clause specifically mention that you still want their share to be given to them. So that's what we do. So please mention that at somewhere in your will manually, this thing, and sign it yourself, get it signed by your witnesses as well. So you can mention it in your will. The statement is on your screen, and inshallah, you'll get a copy of the presentation, and you can copy it from there as well, inshallah. Okay, now more about assets. Now assets, the joint assets can be of 2 types. One type of asset is tenants in common. Tenants in common mean that every person has got his or her own share. For example, if you buy a house and you and your wife decide that each of you would have 50% share, then you are tenants in common. Each of you owns 50% share. But if you are joint tenants, it means if one person dies, 100% of the property would go to the other person. If you have got a joint ownership of a business with someone, if you die, 100% of that business, 100% of that assets would go to the other person. So this is what you need to clarify with your partners, with your spouse and so on, that what sort of arrangements you have. So so it means that the best approach is that you should have tenants in common. In that way, you would have your 50% share. If we die, our share would become open for our inheritance. Otherwise, it would automatically get transferred to the other person. And same is the case with the bank accounts and so on. It might seem easy from the worldly point of view that everything gets transferred to your spouse and so on, but Islamically, it may not be right. If spouse take 100% of it and does not distribute it Islamically, then we'll be responsible for that. So best is to have tenants in common. Or let your wife know, make her an executor, or make your husband as an executor, and let them know of the requirements, that you are very much concerned about your Islamic responsibility, because we are answerable to Allah subhanahu wa ta'ala for that. So let them know and make them accountable. Once you make them accountable, then it's up to them. So they have to follow the Islamic guidelines on that. So what we need to do in this regard is check the status of your properties for the ownership type. Now, should you include the assets in your will or not? There are some will documents which enlist the properties. Like I've got this house and I've got this bank and balance and so on and so forth. The best is not to include that, because when it would change, your will can be nullified because it would not be reflecting the true picture. Don't mention that on the will document. But as I mentioned, have a specific log or a specific register, and then let your executor know about that, where it is, what's stored, what are your key assets, and so on. And in the will, we can use the wording residual assets, and that would include everything. And that is what we have done in our will document as well. Death insurance. So again, you can nominate your nominate your executor in that, or nominate your estate if you have the death insurance. But a disclaimer, many scholars do not consider the death insurance to be Islamic. And I won't go into much detail of that. But if you believe that Islamically it is right and you have got fatwa from some scholar, then make your estate the beneficiary. All right, now we have come to Article 9, and that is about the Testamentary Trust. What is Testamentary Trust? Testament, we know it's about will. And trust is what we call amana, that it goes to someone as an amana, and then that person would give it to their rightful owners at some point later on, in some point in time. For example, if your children are very small, if you've got a 2-year-old, that 2-year-old cannot take care of the wealth by himself. So it has to go to someone. So through your will, you can very easily create a testamentary trust. And our will document has got this section 9, in which you nominate a person or multiple people, usually the guardian, as the trustee. And then that trustee holds the assets on behalf of the young child. And then once the child reaches the ages of maturity, then that person can give it back to them. So I won't go into much detail of that. It is what I have explained would be sufficient, inshallah, to understand this testamentary trust. And if you've got any further questions, you can inshallah ask me. And Islamically, it's highly our very serious responsibility that whatever trust we are given, we should fulfill that. We cannot betray the trust that is given to us. So if you are the one who has been made the trustee, then do your best to pay off the trust in the best manner. And if parents want, they can give some fee to the trustee. For example, they can say that if the trustee is really poor, then they can say that this amount, this fee you can have. And Islamically, it is allowed as well, because there was a companion who was really poor and he asked Prophet ﷺ about that, and the Prophet ﷺ allowed that. I don't have time to explain one more beautiful concept, but I'll just give you a hint. And this concept is called urf. Urf means the common customs. So that is again one of the bases of the Sharia rulings, one of the principles of Islamic jurisprudence, and things are determined based on that. May I request brothers to please keep it mute, please? So this I've already explained when the trust is made, especially when the children are minor. Also, in case someone does not have the right mental capacity, or if someone is in a lot of debt, if you give it to them, everything would get consumed straight away by debt. So you can make a testamentary trust so that their assets are protected. And when they are in the right state, you can give them their estate. So you can set out these conditions in your will. And then his share would be an amana with someone. All right, so now we come to Article 10, which is about superannuation. And in the superannuation also, the single point that I want to convey about this is that you should nominate your estate as your beneficiary, and in that case it would automatically come to your estate, and Islamically it can be distributed. So usually it is our biggest asset, so for most people, so this has to be very carefully dealt with. If we don't nominate that, then the super company can decide who it goes to. Now, alhamdulillah, it seems as if by skipping a few slides and shortening a few sections, will be able to maybe complete it within time. This clause is about separatability. What does that mean? It means that because of some reason, if one clause of our will is not applicable, then this clause states that all other clauses would remain applicable. The whole will document would not be nullified. If there's one clause which is inapplicable, the others would still remain applicable. International will. So the thing is that there's a conventional international convention in which certain countries signed a deal, and those countries said that we will accept the will that is made in other countries. So Australia is one of the signatories to that international treaty about the wills. But as I anticipate, most of the brothers are from Pakistan. Pakistan is not. So if you make a will in Australia, it won't be acceptable in Pakistan if you have got property in Pakistan. But if all your property and all your possessions and so on are in Australia, then it doesn't matter. So you can make this will over here. But if you have got things in Pakistan, then you have to make a will in Pakistan. And the good thing is that the will that you make in Pakistan or any other country, if it meets all the requirements for the Australian will, like it is signed in the presence of the witnesses on every page and all the other things that we have discussed so far, if they are covered in that, then it is applicable in Australia. So a will made in Pakistan based on these requirements that we have discussed would be applicable in Australia, but Australian will would not be applicable in Pakistan because they want it on certain formats and so on. So if you decide that, you can go to Pakistan and then get it on the what we call as stamp papers and so on, and you can get it printed on that and get properly endorsed and attested by the relevant bodies over there. So that was one of the questions earlier on, and I think this is what we just want to discuss in this one. So with regards to the international will, if you are making a will in Australia that you want to use overseas, in those countries which are also signatory to that treaty, then you have to do this thing. The will only be made by one person and in writing, testator to decide, testator the person who's making the will, to declare his or her will in the presence of the two witnesses, just like the other wills as well. A person authorized to act in connection with an international will, he has to endorse that. Who it can be? An Australian legal practitioner. So you have to go to a legal practitioner and get your will endorsed if you have to use it in another country. Like for example, if you've got properties in Canada, or if you've got properties in US and so on, or any other countries which are signatory, then you have to do this. Otherwise, it's not required. So if you have got properties, you go to a legal practitioner or a notary public of any jurisdiction, or there are some other professions, you can go to them and get your will authorized with them. The authorized person and the witness are to sign the will in the presence of the testator. The authorized person is to attach to the will a certificate in the form which establishes that the legal obligations have been met. So this is what you have to do if you have got property spread out in multiple countries. And this is what we have already discussed. Now we come to the power of attorney. Appointing someone as your power of attorney gives them the legal authority to look after your affairs on your behalf. They can do financial transactions on your behalf. And this attorney, this permission is of two types. One is a general power of attorney that you give it for specific time or specific purpose and specific deal and so on. The other one is enduring power of attorney that stays for a long time and endures. So these are the two different types of documents. We have not included them in our will because they're not officially the part of the will. But if you want, you can go to a local lawyer and you can delegate your financial decision-making ability to someone if you like, or maybe your spouse or someone. Guardianship is basically if you get sick and you want certain people to decide what needs to happen to you, when to pull the plug, when to treat you, when to maybe do certain type of treatments for you. So you can give that authority to someone through the power of guardianship. You can also write anticipatory direction that if this happens to me, this should be done. If this happens to me, this should be done, and so on, from the medical point of view. All right, now this question which many people ask is about storing the will. Short answer is that you are not officially required to deposit it anywhere, but there are certain places where you can deposit if you like to. You can keep it at home if you like. You can deposit it in a bank, in your locker, and so on. Your accountant or lawyer can also keep a copy of that. In WA, there's a free service called WA Will Bank. You can deposit it to that. In New South Wales, there's a New South Wales trustee and guardian, and they've got a very minimal fee. From what I remember, I think it's $29 or $45 once off. So that's what you need to do if you want to deposit it with them. And I think it's a good thing to do, to deposit it with them. It's secure, and your executors won't have to search for that. They would know that he has or she has deposited in the will bank with the trustee. So I can just go there and get it issued from there. You can also use the registrar of probate in the Supreme Court to store your will. But from what I have understood, that it's not used a lot in New South Wales. New South Wales trustee and the guardian, I think, is the preferred option. And you can tell your executor your will, where your will is, so that they don't have to search for it. And if someone dies without telling you where his or her will is, that these are some of the places where you can check. And these are all the common sense things, so I won't go into a lot of detail of this one. Article 12 is conclusion. So the conclusion in this Article 12, if you look at the will document, we say that we are in all of our senses, and then on this date and so on, and this time in our full mental capacity, and with an intention to execute this will, I'm signing it, and these people are witnessing it. So that's about the thing. So Alhamdulillah, we have been able to complete it 1 minute before the finish time, but the question and answers might take some time. So inshallah, I hope that Humayun Bhai would have the questions from both the groups, and inshallah we can start with the questions, and I'll try to answer them as briefly as possible.
जज़ाकल्लाह नबील है, मैं क्वेश्चंस शुरू से रिपीट कर लेता हूँ ताकि अगर कोई पहले एड्रेस नहीं हुआ था तो वो भी हम रिव्यू कर लेंगे, और अगर जो पहले हो चुका था उसको क्विकली हम स्किप भी कर सकते हैं। आई होप दोनों ग्रुप्स में आवाज आ रही है?
Yes, we are fine. I'm fine.
Yes, so they can hear as well. They have said.
ठीक है। तो पहला सवाल जो था वो मिनिमम इस्लामिक एज ऑफ मेकिंग अ विल था, उसका जवाब आपने दे दिया था। फिर उसके बाद दूसरा था कि हाउ टू मेक विल फॉर कस्टडी ऑफ चिल्ड्रन इन केस पेरेंट्स पास्ड अवे हियर इन ऑस्ट्रेलिया।
So I think that bit is also covered. So we said that you can have multiple guardians nominated, and the best is to have some local guardians as well. I hope everyone is able to understand Urdu. If there are any brothers who are not able to understand Urdu, then they can let us know, and we can repeat the question as well, inshallah. But if everyone is fine with that, inshallah, we'll continue in English, inshallah. So yes, so you can have multiple guardians. Better to have someone local as well, because as I mentioned, court would have certain conditions that they would look at before allocating someone as guardian. One of them is the financial condition and so on. So best to have someone local as well.
All right. The next one is, can wife be one of witness?
No, it's better to not have any beneficiary in the witness because there can be a conflict of interest. Best is to have neutral people as the witnesses.
Thanks. Next is this will also valid for Pakistan or abroad?
I think this is
or
what
do
we have, I think this is what we have covered in the last section. So if it is made on the format that is used in Pakistan, then that will is acceptable in Australia. But Australian will as such on the format that we have might not be applicable in Pakistan because in Pakistan they want it on certain formats and so on. But vice versa would work.
I think with that you have answered the next one as well, which is can this will be used in other countries as well? So probably for that as well, we have to follow the local laws. The next one is there any requirement to register the will to any authority like service, NSW, or registered lawyer firm? I think you have responded that in the last slide.
Yeah.
But
there's not a legal requirement, but if you want, you can use the public trustee, and I think I would recommend to do that. So please, I would recommend to please use the public trustee and deposit your will with them.
All right. Next one was, can we update will time to time?
Yes, you can. And if you make a new will, your previous will would be revoked and your new will would be the current one. And you can also deposit that with the public trustee again, whatever new will you make, so that they know that this is the latest version.
Next one was, my will was signed by 2 lady solicitors. Do I need to find a male now? Which you responded that it is okay.
I think it's okay, inshallah. Legally, it's okay. Islamically, it's better to have male witnesses, but in my personal humble opinion, it's fine, inshallah.
If one witness dies, then do we need to redo the will?
No.
Okay, the Islamic will template which we have shared, is that verified by lawyer or legal expert?
Yeah, I think we have answered this one, yeah.
Can executors be the beneficiary? Because isn't this a conflict of interest if wife or son are the beneficiaries in that case?
No, in many of the cases that I have studied and in many of the recommendations from the lawyers, that's not the case. So they can be, because in fact, if we don't make them the executor, then they won't have any access to the funds. They are the people who know about our situation and our condition the most, and we can give them certain salary as well for being the executor, certain fee, so that they can make their expenses and so on, or they can take from their shares and so on. So that's fine, inshallah. Because you know that sometime it can take up to 12 months to pay off all the shares to distribute. Till that time, our family would be void or deprived of our assets. So how would they maintain themselves if you've got young kids and so on? So it's best to have it within the family when possible.
Sure, thanks. Another one is somehow related to this one. Who will be executioner? Is it wife or lawyer? So I think the response is whoever we have nominated as executioner would be actually executing it.
Yep.
What if the witness passes away before person? I think that is being responded as well in the discussion. Okay, the next one is how to best choose an executor.
So the best one is your wife or spouse, husband or wife. That's the best executor. And then you can nominate someone who has got the legal understanding and who's available locally. That would be the best thing. And then if no one is available, then you can maybe nominate a local Islamic body, and they can also work as an executor if they are willing to do that. But best is to have your spouse or close friends, and then someone available locally.
Okay, the next one is for online wills. Witnesses are physically present with you when you sign electronically. Does that classify? I mean, I think they are trying to ask that can a witness be signing off online, or it has to be physical?
I don't think it can be done online, so it has to be physical, in my personal humble opinion, because there can be so many issues. The will can be challenged and so on. So we should not leave any caveat and get it signed as the law says in writing in the presence of 2 witnesses.
The next one is is the discussion also valid for Victoria, which I think it is, and it's valid for across all the states in Australia.
Yeah, but I think we'll need to double check that one, because I had prepared this version of my presentation for Western Australia, and today I decided to study in detail the New South Wales legislation. And there were a few points, most of the things were similar, but there were a few points which were different in New South Wales. So best to check about Victoria as well. And inshallah, we can also, I can also try to study, but also you can seek help from the local lawyers and so on, and they can inshallah help you.
Next one is, if we have property, land, and it's not paid off, how will that be distributed, or what would be the case in that scenario?
So whatever share that you have and whatever you have paid off, so that would become part of your estate. And whatever you haven't paid off would also be part of your estate as debt. So that debt would be taken off your estate. And if all of it is consumed in paying that debt, then your estate might be negative. Legally, you won't be responsible, but Islamically, you'll have to pay off that debt. If you want to hold that property. Otherwise, if it can be sold and then you can get free of that debt because of that sale, then that is what the executor would do.
Okay, thanks. So the next one is, I think we covered that later, but probably if you can elaborate a little bit. So the question is, how many different people are involved in the will? Executor, beneficiary, witness, and testimony person as well. So how many people are overall involved?
Yeah, so testator is the one who's making the will. Then there would be witnesses, at least 2 witnesses, plus there would be an executor, there would be a guardian. You can nominate an arbitrator who would resolve the conflicts and so on. Plus there would be beneficiaries. If you nominate someone other than your guardian as a trustee, so that trustee would also be a part of the will and so on.
Okay, next one is, will a stepchild be part of the will as well?
Islamically not. So, but you can, a stepchild, it depends. Like if it's an adopted child, then Islamically it's not. Otherwise, there are certain conditions in which the stepchildren can be included in the will. And again, that comes to that detailed session. If you wanna have a quick look, what you can do is that you can look at Appendix 1. There's only one appendix. We have called it Appendix 1 in the will document, and that specifies all the shares. So there are some shares for the brothers, etc., who are from the mother side, and there are some shares, etc., who are from the father side but from a different mother. So there are some shares for those people. So you can have a look at Appendix 1, inshallah.
Next one is a bit long one, but I think we have covered that. If a nominee or executor dies, but I'll read that out. What level of nomination is recommended? Then there is an example that if person A nominates person B as heir, but what if person B dies along with person A? To consider that scenario, he might nominate a second level nominee like person C, but there is a possibility that person C dies along or just few hours after that person.
Yeah. So that's like, we do not deal with all these hypothetical situations, and we do not nominate people as well Islamically. Islamically, the shares of inheritance are determined or are directed by Allah subhanahu wa ta'ala. We don't have any choice in that. We do not nominate or not nominate anyone. It's from Allah subhanahu wa ta'ala. We don't have any choice, and Allah subhanahu wa ta'ala is very particular about that. You know, the science of inheritance is also called ilmul faraid. So ilmul faraid, it means that it's the science of the mandatory thing. So it's so much mandatory, and Allah subhanahu wa ta'ala says about that in the Quran, farizatum min Allah. I just want to explain these shares and say farizatum min Allah. It's definite obligation from you, on you, from Allah subhanahu wa ta'ala. So do not be laxed about it. So Allah subhanahu wa ta'ala has given the shares. That is what we have to do. If someone passes away with us or shortly after us, or within 30 days after us, or later on as well, so we have to give them their share. So Islamically, so that is why we say that we have added that clause in the New South Wales wills, that even if someone dies shortly after us, still their share has to be given to them, which would then go to their beneficiaries. Yeah.
Jazakallah, Nabeel bhai. The next one is, does the will has an expiry?
No, it doesn't have an expiry, and there are certain conditions in which it can become void. For example, if you marry, and if you had named your children in the will, and the new child is born, in those situations it would get null and void. But otherwise, if those situations don't occur, then the will is valid.
Sure. Are committee payments also in loan category?
Committee payments, I'm not 100%. Some scholars, to be honest, some scholars consider it not right. The committee, forgotten the name for that one. There is an Arabic name for that as well. So some scholars do not consider it permissible, because the principle is that ayu qardin jarra naf'an fahuwa riba. Any loan, it's a type of loan. Any loan that you give and you take benefit from it is not allowed. So some scholars don't allow that, and some scholars do. But if you have got an obligation, you have already taken your share and spent it, and you still have to make your payment, then yes, it's a debt, and it has to be paid.
Okay. Again, I think this is a similar question. If we have a house that is not paid off and it come under the loan that needs to be paid immediately before burial, if yes, what's the process?
I will explain. I'll take few minutes on that one. I know it's already 12 minutes over, but this is a very, very important point. So any brothers and sisters who are not yet on Islamic finance, I would strongly recommend them to be on Islamic finance, because there's a lot of difference in how, and I know some of you might not have an overview of what the difference between the two is, and some of you might be thinking it's all the same, but you can trust me that there is a lot of difference, and Allah subhanahu wa ta'ala has told us to go for those principles for a reason. So if you die and you have got a loan from a conventional bank, then yes, it's a debt. Those 100,000, 200,000, 300,000, it's a debt on you which has to be paid. So what would happen as a result is, Islamically, if you have to meet your obligations, you have to pay, sell the house and pay off the debt, or someone from somewhere else, the money has to be gathered. But in Islamic finance, what happens is that you buy a portion of the house every month, and then whatever you haven't bought, you pay a rent for that. So you're living in their house, you pay the rent for that, and every month you buy a chunk of it. So if you die in that state, there is nothing upon you. So you were just paying rent, you die, you don't have to pay rent. So it's much better for your soul to reach its destination. So that's what has to happen.
Jazakallah. Executor can be beneficiary as well. If this is already done. If the executor is located in Pakistan and the person has a will in Australia, how will the government transfer all the assets to that person, or do we need to nominate the person?
They have to come in here. So the best thing is that we should have someone local. And if we really don't have anyone local, no trustworthy person, no member of the family, then we can nominate someone from overseas, but it will be very difficult for them. They'll have to come here, and considering the given situation with the visas and so on, they'll have to come here, apply for the thing. They have to have understanding of the law as well, because to deal with all these things. So it can be very difficult for overseas people. So best is to look someone locally. But otherwise they'll have to come and then apply and follow the same procedure.
Okay, the next one is superannuation has binding nomination. They don't know about executioner. How executioner fits in superannuation?
So the executioner, when they get the grant of probate, you should have told them that this is where my superannuation is, and when they get the grant of probate, then they can go to them and get hold of the funds.
If next one is, if both the testator and executor die together in any accident, like in case of spouse and second executor is also one of our children who die in the same accident, who will execute the will then?
Another beneficiary can go to any other beneficiary can go to the Supreme Court, and then they can request for the grant of administration, and then they can administer the estate on the behalf of the deceased person.
Next is, can we allocate a guardian locally to send the children overseas to relatives?
I don't think government allows that, as for the conditions that I mentioned, because the government is very, very concerned about the well-being of the children. So best is to have someone locally, and I don't think it's in many cases it would be approved to send the children overseas. And we have seen some cases in which it's not approved for them for their children to be sent.
The next one is a bit similar, but I think for overseas you have responded. But what I understand from this one is, if parents are based locally can they take my kids from guardian?
Sorry, I didn't get the question.
If the parents are locally available and the kids are with guardian, can they take from guardian?
So guardian is overseas, yeah.
Guardian is here and parents are here as well.
So I don't know why the kids would be with the guardian and not with the parent. So that might be a complex matter. So maybe you can seek
And
assistance.
just for the case, for elaboration purpose, Nabeel bhai, if we assume that guardian is overseas, then what would be the scenario in that case? And parents are available locally.
So that depends on the will that that person has made. And I think Australian government might support them, but this is a very unusual case, and maybe further legal advice would require to be sought if such a situation arises. And I'm not 100% sure of the answer to that.
Okay, the next one is there are two components of that. It does status of the visa status of guardian matters, and who will bear the guardian expenses later on.
If the testator wants, they can give certain fee for service to the guardians. They can say that guardian from my estate would be paid $2,000, $3,000, or whatever for this amount of time for taking care of well-being of the children. And Islamically, this is allowed as per the hadith that I showed on the screen. So they can be given certain fee for their service. Was there a first part of the question as well?
The first part was any condition on the visa status of guardian.
Yeah, so I don't think it matters. In my personal opinion, it doesn't matter if they are available locally. You can nominate them, and hopefully there won't be any issue with that. But as I mentioned, government is very keen about the well-being of the children. If they would feel that the well-being of the children could be compromised, then the outcomes could be otherwise as well.
Jazakallah. Next is it necessary that we nominate someone as guardian who is foster carer as well?
No, I don't think so. That's a requirement.
The next is bequest mandatory?
No, it's not. It's optional, but highly recommended. If your kids would have enough and they won't be left in poverty, then it's recommended to do so, because that's your last sadaqah jariyah that you can give before departing this world.
Okay. There is a request to repeat the condition, the event in case executioner passes away within 30 days of one's death, specifically in NSW.
Yeah, so executor death is not the thing. So their executor would become the executor. If one executor dies and the next one takes on, if that dies, the next one takes on. If all of them die, then the executor of your last nominated executor would also take care of your property and distribute that as well.
Okay, the next one is a different request. Can you please quickly go through the will template, and can I edit or adjust the wording of will statement or remove or customize?
Yes, you can do that. And when you do that, you and the witnesses would need to sign that one. It won't be possible, I think, to go through all the elements of the will document over here. But if you want, you can maybe give me a call, or maybe we can have a chat later on, and inshallah, we can discuss anything.
Can we write a statement that all my estate to be distributed as per Islamic rulings and then witnessed by two people?
Distribution as per Islamic way is already mentioned in there, but witnessing we haven't mentioned, because we are already requesting the executors to do that, and they are legally responsible to distribute as per our directions. So they are, once we nominate that, they're not just answerable to us, they're answerable to the law as well, that they have distributed Islamically. Now, on top of that, I don't think personally that there's any need, but if you want, you can add that and get it signed by the witnesses and so on.
There is another one on committee, actually. The question is, if committee is already received, then payments that need to be paid should be a debt, as understood?
Yes, it's a debt, yeah.
Okay, then there are a few here as well. Just one sec.
Nabeel?
And I apologize to the brothers that we are taking a little bit longer, but I think the session is done. So if anyone wants to leave, they are free to leave, but we'll just go through the questions quickly, inshallah.
No, Nabeel, one question. Can you hear me?
Let me finish the questions which are already there in the list, and then we can take the questions once we are finished.
Okay.
Jazakallah. What's the identity number we need to use in the template? Shall that be a passport number, or do we mention in bracket, or what it should be?
Maybe use some local identity number like a driving license or something. That might be the best thing, I think. Or it can be any identity number, and the purpose of that is because there would many people with the same name. There might be many Humayun Mustafas in Australia and so on. So just to identify which one it is, so you can mention an identity number.
Can we have multiple executors?
Yes, you can either have multiple people nominated in sequence, like if one is not there, then the other, or you can have multiple people as joint executors or joint and severed executors, as we discussed, and the details would be available from the relevant slide, inshallah.
Next is, who needs to sign on the last page of Schedule A? Is it only the testator?
It's a very, very important point that you have highlighted. The thing is that on every page of the appendix or Schedule A as well, the testator and both the witnesses have to sign on every page. On those pages, we don't have the format available for the witnesses to sign, but witnesses have to sign on every single page of the Schedule A as well, and the testator as well.
This is similar one which we have covered already. How to allocate shares to stepchild?
How to allocate?
How to allocate shares to stepchild?
So they can be given shares through stepchild, as I mentioned, that there are certain provisions for them. But if it's adopted children and so on, then you can give them from the Wasiya. And if even your stepchildren are in a situation where they don't get the inheritance, they can also be given through the Wasiya. And some of the conditions we have discussed, the Mawane are.
Next one we have covered already. If nominated guardian are abroad, do they need to come to Australia? We have covered that. If the will prepared in Pakistan and mentioned about children custody, will it be accepted in handover children to the guardian in Pakistan?
I'm not sure about this one. So this depends on how much they can enforce, and I doubt that government of Australia would send the children for that purpose. So local will would take precedence. But again, it's a complex legal matter, so maybe lawyers can help with that.
Isn't it better to have power of attorney in place? Your only will kick, which will only kick if one die. Power attorney will allow your spouse to take charge of your account state in case you go to ventilator or life support. Officially, you haven't died yet, or probably they want to ask, I mean, if there is any financial support needed while you are sick and in the hospital.
So you can sign the enduring power of attorney in that case.
Okay, there are the next one has two components. Do we have to get this will attested by JP after it is signed by testator and witness?
No, unless you are willing to, or unless you are trying to use it for international acceptance, then you can do that. Otherwise, there's not a need. Let's take let's aim to close till 8:30. Otherwise, it might be too late for the brothers.
Sure, sure. So we'll cover whatever questions are coming in till 8:30, and probably the next remaining we can cover in email or messages later on. Inshallah. Can we allocate inheritance to parent siblings who are overseas? How will that be transferred from here?
Yes, certainly, and it's an Islamic requirement. So someone would need to collect on their behalf, or they would come. But Islamically, we are required to give them the share which has been prescribed by the Quran and Sunnah.
Can we make overseas parents or siblings as guardian instead of foster parents? Yeah,
I think this we have covered already a few times.
This is again in inheritance? Yeah. Is there any tax on inheritance?
Yes. So basically, all the tax returns would have to be submitted for the months that you were alive, for those months, plus also for the estate. So for that, executor will have to seek services from an accountant and so on.
Okay, one brother has shared an information that deposit of will in Victoria is statetrustees.com.au. Okay, the next one, if her husband and wife nominate each other as executor and both die in the same, probably same accident or same time, who would be the executor in that case?
Whoever is in their will in the next year as executor.
For updating a will, do I need to start that from scratch?
It's up to you. Better is to do that to start the will. Otherwise, you can make the amendment, but you would have to amend the copy, the latest copy. For that, you might need to get it recalled from the public trustee and so on. So best is to make a new will and deposit it to them. And it's free, as you know, that we don't charge any fee for anything. So this template is available. Make it again and submit it.
I think this is similar, which we have. Next one is which we have already covered, but I'll read it out. Can guardian allow children to go overseas? Like we set our cousin as guardian, but we want after our death, children go to grandparents in Pakistan.
I think this one is covered. So the preference is to have someone locally, or in some cases, I've heard that if you have got brothers and sisters who are in countries which have got the same socioeconomic conditions like Australia, for example, Canada and so on, then that might be okay. But generally for other countries, it might be a problem.
The question next is particularly with respect to executors. Can executor keep the copy of will? But I'll extend that who else should have the copy of the will?
Best is not to have too many copies of the will, because if you make a new will and then you don't give it to everyone that you had previously given it to, then there can be disputes. Someone would think that this is the final will. Another person would say that this is the final will. Otherwise, what you can do is that you can make a list of whoever you have given the copy of will to, and then if you change it, give it to all of them again. Otherwise, there would be issues and people won't be sure which one is the final one and which one someone has forged. Because at the moment, we are just like middle class people, but some of us may become millionaires or billionaires later on, and then these things can be critical.
And I think, yes, that was the last of the lot. Asad bhai, have we covered your question already? Asad Kazi bhai?
Oh, no, it was me. I'm not sure somebody else was.
Okay, okay.
So my question is, that's what you have mentioned already. Maybe Nabeel bhai has not taken it properly. So let me.
Maybe inshallah, then we'll move towards closure.
No. Let me read it again. So just like a brother said that written down somewhere.
Or there's anything else?
Yeah. Maybe the question is different way.
Yes, please, Asad bhai.
Yes, Nabeel bhai, let's take this last one from this brother, and then we'll close it.
Can you hear me?
This brother, please cover.
So can we write a statement that all my estate to be distributed as
is
per
someone
Islam?
sending the question?
No, he's not.
Nabeel bhai, the gentleman is reading it actually. If you can hear that,
I can't hear it.
Oh, okay. I'm not audible still. Hello.
I can hear you.
Okay. Maybe Humayun bhai, you can read that.
Okay. You tell it to me, Nabeel bhai. Just give me a few seconds. I'll listen and then I'll tell it to you.
Let me send it to the chat again. You can read it again. Maybe Nabeel bhai didn't took it properly. Yeah, you read it again, please.
Okay.
So that's in the chat. Can we write a statement that all my estate to be distributed?
Okay, so it's Nabeel bhai, it says, can we write a statement that all my estate to be distributed has to be as per Islamic rulings and then witnessed by two people?
Yeah, this we have already answered.
So Zia bhai, we have already covered this. What is your particular question?
I think the question is, brother is thinking that instead of going into all details of the writing a complaints document, just if he writes a statement like whatever he can.
No. We have to specify the shares. Otherwise, there would be a violation of a thing. There's a thing which is called delegation of the will making authority. If we don't mention the actual shares or the way of calculating the shares, then it would be violation of that, and the will can be considered as null and void. So we cannot just say that Islamically it has to be distributed Islamically and witnessed by. We have to give the details of the shares, but we don't give the shares by name. That is why we have added a table. So that way we are avoiding the violation of this thing which is called the delegation of the will making authority. So good question.
Jazakallah, brothers. This was the last one. Over to you, Nabeel bhai and Nasir.
Jazakallah khair, Nabeel bhai. Actually, your introduction to the first ever thing that you've done. But I didn't want to make you uncomfortable, so I think to Nabeel is very much I can, and I initiated this time and whatever knowledge is shared. Initially, we wanted to do this program as a on Virasat, and it was going to be another 4 to 6 hours long, 3 to 4 sessions. So I thought, first of all, do it, and then on people are interested, we asking people, one of the people who got in contact with us, and we asked them if they want to know how this Virasat and how the distribution of things done. Then we can go into that. Regarding this particular session today, what I think personally is you may not be able to actually write a comprehensive document, but in essence, we have been able to know what exactly a lot of terms in terminology in the document and what they mean and what they should be. And keeping that understanding in mind, if we right now we go to a solicitor and ask him to write something for us, then in that we'll be in a better position to find out if there is something not right, and we can respond to get that right. Also, before down the line, we are thinking of having similar other sessions, and we also make more people places. Initially, there was 40 people who were supposed to join us, but however, people not there, and you are trying to make it happen. I think there was some big hiccup because the mail was landing in their junk mail, and some people missed that out. And we really sent SMSs for people, and I think most of them they got on board. Thank you very much, Jazakallah khair, all of you joining for this long session, and thank you for having this, this long session. It was really a lot of energy from your side. I understand that you didn't sip of water with all this 2.5 hours. So thank you very much.
Jazakallah, brothers. So let's finish with the dua, inshallah. Subhanakallahumma wa bihamdik. Nastaghfiruka wa natubu ilayk. Nashhadu an la ilaha illa ant. Assalamu alaikum wa rahmatullah.
Wa alaikum assalam wa rahmatullah.
Wa alaikum assalam.
Jazakallah. Thank you.
Thank you so much.